and then we'll have the Q&A for 10 minutes, right?
More like 40 to 45, I think. Yeah.
40, okay, done. And then maybe I could give you a time check via personal message on Zoom when
Sure.
sort of that.
Yes, if I'm running over time, please tell me, but I don't think I will.
Okay.
Of course, nobody ever thinks they will.
We're very, very honored. Ma'am Ishan was telling me that this is the first time that you are talking to an Indian audience. We're very, very
Yes, it
grateful.
is. Yeah,
It's
it's an exciting opportunity for me. Thank you.
great, thank you. It says that we are live on YouTube. Greetings, everyone. Good morning, good afternoon, good evening to all the people who've joined us from all over the world. My name is Chandni Jaswal, and we are here with another YouTube special lecture here at Karwa, the Heritage Exploration Initiative. Today, we're joined by a very, very special guest here at Karma Heritage, and it is Professor Sandra Wilson. A quick introduction to Professor Sandra Wilson's work. I'll try to say as much as I can in the 30 seconds that I have. Dr. Sandra Wilson is Professor of Asian History at Murdoch University in Australia. Professor Wilson specializes in the history of modern Japan, especially the period from the 1930s to the 60s, with a focus on nationalism and on the Second World War. She is a recipient of numerous awards, including the Vice Chancellor's Excellence in Research Award, Best Research Output in 2021, and holds fellowships at the Australian Academy of the Humanities and the Royal Historical Society. Professor Wilson's current collaborative research concerns war crimes committed by the Japanese military in the Pacific region between 1941 and 1945, the war crime trials that followed the conflict, the post-war settlement between Japan and its former enemies, and the representation of Japanese war crimes since 1945. Professor Wilson's lecture here at Karma Heritage is titled Problems of Justice in War Crime Trials, Allied Persecutions of Japanese Suspects from 1945 to 1951. Just as Professor Wilson and I were speaking, Professor Wilson would be speaking for 40 to 45 minutes, which would be followed by a 10 to 15-minute Q&A session. We invite questions via the live chat option that you have on your YouTube screen, which would be taken up once the lecture is over. So without further ado, I now invite Professor Wilson for the lecture. Thank you very much once again, ma'am, for choosing our platform to address the Indian audience on a topic which, even though has generated a lot of interest, is seldom talked about in the subcontinental region. So thank you for choosing this platform to share your work. Over to you, ma'am.
Thank you very much for that generous introduction. And I'd like to thank Karwan Heritage for providing me with this wonderful opportunity to talk to a new audience, my first Indian audience, as you said, about some of my recent work. It's a great opportunity for me. So there is my topic. After the Second World War finally ended in August 1945, the victorious Allied powers embarked on a really ambitious program of reckoning with their defeated enemies. So that meant both the Germans and the Japanese. Nothing on this scale had ever been done before, and nothing of the same scale has ever been done since. So these were truly momentous efforts. The Allies' objective was to punish individual perpetrators of war crimes, but also to set an enduring standard for the future conduct of war. They had a very elevated view of what they were doing. The proceedings against Nazi war crime suspects in Nuremberg, which began in late 1945, are very well known. In Tokyo, there was another large international trial that was modelled on the Nuremberg trial, called the International Military Tribunal for the Far East, or the Tokyo Trial, it's often called. It ran from 1946 to 1948. In these proceedings, the Allied powers prosecuted Japanese civilian and military leaders for two types of crimes. First, waging aggressive war, that is, crimes on the broad political and military level of getting Japan into the war and the way it was waged. And second, issuing orders that had led other personnel to individual and mass brutalities against prisoners of war and civilians in Japanese occupied territories, especially in Southeast Asia. There were 11 judges on the international bench, including the famous Indian Justice Radha Binod Pal. You would probably recognise this scene. It's former Prime Minister Tojo Hideki standing in the dock. Another set of trials also took place in Asia, some of them in Japan, and others scattered around about 50 different venues across the Asia-Pacific region. For example, in Darwin, in New Guinea, in Singapore, Kuala Lumpur, Hong Kong, Manila, and Manus Island, which is off in New Guinea. You see from this map, the impression I wanted to show you is simply how many places there were. All the places named on this map were venues of war crimes trials. So they happened across a very wide geographic spread. These proceedings were not international in the same sense that the Tokyo trial had been. They targeted individuals accused of personally committing crimes as well. That's another difference. It wasn't the leaders this time. They targeted military personnel in the field rather than leaders in Tokyo. The trial stretched between 1945 and 1951 in military tribunals as opposed to the international bench of the other trials, and they were run by 7 separate Allied powers. These Allied powers, which I've listed there, Australia, Nationalist China, France, the Netherlands, Indies, Philippines, the UK, and the US, they operated independently, but within a kind of a loosely collaborative framework. The court procedures ran also according to separate national legislation, or regulations anyway, but to varying degrees, these different powers did things like exchanging defendants or evidence. They even accepted foreign judges on the benches in their courts. In addition to this, the Soviet Union and the People's Republic of China later on also ran war crimes trials of Japanese suspects, but they didn't cooperate with these other 7 allies. They were rather separate enterprises, these judicial proceedings, and the China ones were considerably later. What I want to do in this lecture is to discuss the Allied trials of Japanese war crime suspects that I've just outlined, focusing on the problems that came up in the effort to reach just decisions about war crimes. I'll concentrate on the proceedings that took place in the national military tribunals, these ones I'm showing you on the map, rather than the International Tribunal in Tokyo. And at the end, I'll try to make some general comments about what has happened in subsequent decades in the pursuit of justice for war crimes that have been committed after 1945. In assessing whether an act of brutality was likely to be a war crime, there were 2 core principles under international law at this time. The first is that the action in question was not essential for military purposes. So, for example, killing an enemy soldier in battle is not a war crime because it's directly related to military goals, but killing soldiers who've surrendered is a war crime because they are no longer fighting. And similarly, killing prisoners of war because they're prisoners is a war crime. The second question is whether the action was reasonable or what we'd now call proportionate. Killing suspected guerrillas, for example, might be legitimate. It's not even necessarily illegal, but killing an entire population of a village, including women and children, on the grounds that the village might be harbouring guerrillas, even definitely was harbouring guerrillas, is not reasonable, and it was and is illegal under international law. In the national tribunals run by those 7 Allied powers, about 5,700 Japanese military personnel were brought before the courts. They were charged with a variety of offences. They included charges like massacre, individual murder, torture, beatings, cannibalism, forced marches, neglect of the health and welfare of detainees, and prisoners of war, both prisoners of war and civilians in occupied territories. POW camps were a particular target, and overall 27% of guilty verdicts were related to offences committed in those camps. About 4,600 Japanese defendants were found guilty of at least one charge. Most of them received prison sentences, and about 920 were sentenced to death and executed. At first, the convicted war criminals were held in prisons all over Asia. Here we have a group in Borneo, I think it is, in rather makeshift courtrooms often. They were tried, in other words, near to where the offences had been committed and in territories that were under the control of the sentencing powers, usually meaning the old imperial powers in most cases. There were practical reasons for this. That's where the soldiers were. So it was easier to run trials in those places on the whole. But another motivation was that the Allied powers wanted to demonstrate to local people that justice would be done for the crimes that had been committed against them. A peace settlement was reached between Japan and its former enemies in 1951. And the following year, the war formally ended when the San Francisco Peace Treaty came into effect. The treaty contained an article, Article 11, that specifically referred to what would happen to convicted war criminals. By this time, the trials were over, but lots of them were in jail. The Article 11 declared that the powers that had convicted each individual war criminal would retain control over his sentence, meaning that no decision could be made on early release, on clemency, parole, anything like that, without the authorization of the sentencing power. The Japanese government could only make recommendations for clemency, which it did with great gusto. A complicated series of bilateral negotiations between Japan and each of the sentencing powers over clemency began between Japan, as I said, and those powers. It began in 1952 and it lasted through to 1958. By the time the peace treaty came into effect, 1952, some of the Japanese military personnel who'd been sentenced to short prison terms had already been released, either because their terms had expired or under a parole system. And of course, some of them had been executed. By the end of 1953, after negotiations between Japan and the sentencing powers, all of those who were still in custody had been sent back to Japan if they were initially held overseas. Some of them had been tried in Japan and therefore were already there. They were now to serve out their sentences in a prison in Tokyo called Sugamo Prison. Sugamo had formerly been run by the American military in the period when Japan was under Allied occupation up to 1942. But the Japanese authorities now took it over when the treaty restored Japanese sovereignty. But as I mentioned, under the provisions of the treaty, the control over the sentences remained with the prosecuting powers. Over time, those powers reduced many of the sentences through parole and clemency procedures in processes that closely paralleled the same treatment of German war criminals and pretty much on the same timetable. All surviving Japanese war criminals convicted by those 7 Allied powers had been released by the end of 1958. The Allies' post-war trial project in Asia was driven by 2 impulses. First, a crude desire to avenge the brutalities that Japanese soldiers had inflicted on those who came into their hands during the war, and second, a righteous desire to establish and reinforce the same principle that was also being laid down in the trials of German war criminals, that is, that atrocity against prisoners of war and civilians in wartime could be and would be punished in legal tribunals. At the time, these matters seemed fairly straightforward. Guilty people should be punished. Political and legal authorities expected that proceedings would be straightforward and that the prosecutions could be done quickly. Some officials thought that it would all be over in a few months, which turned out to be far from the case. It was much more complicated than they had expected. For a start, there were a great many practical problems. It was hard to gather evidence because witnesses were often missing or dead or had left the region that was under investigation. Written evidence might have been destroyed if it had ever existed in the first place. Suspects also might be dead or impossible to locate. The breakdown of law and order all over Southeast Asia after the end of the war sometimes made investigations physically difficult and dangerous, and investigation teams were always short-staffed. But it was not just a matter of these practical problems. In determining what might constitute justice in the circumstances of the immediate post-war period, the endeavour to procure justice faced, I think, 3 major conceptual issues. And I'll argue a bit later that these issues or their consequences have not been resolved and are still with us today. First, the jurisdiction of the war crimes tribunals extended at that time only to subjects of states that had been enemies of the Allies, which meant in the Pacific region, Japanese people and the inhabitants of Taiwan and Korea, because those two countries had been colonized by Japan in 1895 and 1910 respectively, and thousands of Taiwanese and Korean men had served as colonial subjects within the Japanese military as Japanese. Their nationality was Japanese. Many of them served willingly, many of them served less willingly. Most of them were formal members of the armed services, but quite a few, including numerous interpreters and camp guards, remained civilians while being attached to the military. They were called civilian auxiliaries. All suspects brought to trial for war crimes in the Pacific Theatre, therefore, were Japanese, Taiwanese, or Korean. This restriction as to nationality arose in the first place because international law concerning war crimes had first of all emerged as an exception to what is called belligerent rights of soldiers. That means the right of soldiers to kill enemy soldiers and to destroy enemy property without being charged with murder or theft or destruction of property. The use of barbaric weapons such as dum-dum bullets or perfidious tactics such as false surrender or the killing of prisoners were declared to be war crimes for which the victimized side could prosecute the perpetrators so long as they could catch them. That was the older situation. When the Allies formally declared atrocities against civilians or surrendered soldiers to be war crimes for which enemy soldiers could be prosecuted, they didn't remove this assumption that the jurisdiction of military tribunals applied only to enemy soldiers. The consequences of this restriction, the main consequence, I think, was the perception of a double standard, a perception that grew stronger over time. Allied soldiers couldn't be prosecuted under international law for any of the actions with which Japanese soldiers could be charged, most notably the killing of surrendered prisoners, which was a crime committed by every side in the Second World War. There was another even more serious consequence. At the very same time that the trials of Japanese military suspects were going on, or shortly afterwards, Western colonial soldiers in Asia were fighting nationalist revolutions, seeking independence from Western colonialism. In the war crimes trials I've been talking about, Japanese soldiers could be prosecuted for mistreating civilians of occupied territories in the course of counterinsurgency operations. That means while they were pursuing and interrogating locals who opposed or were thought to oppose Japanese occupation. But Western colonial soldiers in Asia who were fighting nationalist revolutions couldn't be held accountable under international law for torture or summary executions because their victims were deemed to be their own subjects. So it's the problem that there had to be enemy nationality. Malayan opponents of British rule were deemed to be British and therefore were not the enemy. Indonesian opponents of Dutch rule were deemed to be Dutch. In the Indonesian city of Makassar, there it is on the map, the red dot. In 1946 and 47, a Netherlands Indies War Crimes Tribunal prosecuted dozens of Japanese defendants for war crimes at exactly the same time that a Dutch counterinsurgency commander was engaged in brutal operations against local nationalists, including mass executions. In other words, much the same crimes as the Japanese had committed, but could not be tried under international war crimes law. In the Allied war crimes trials straight after the war, Japanese defendants were not permitted to raise in defence or in mitigation any suggestion that Allied soldiers might have committed similar crimes, either in the same conflict or in other conflicts. A few defendants or their lawyers on the Japanese side did try to raise the issue, particularly of Allied bombings of Japanese civilians during the war, including the atomic bombings, to point out that the Japanese were not the only ones to kill civilians. The courts ignored or rejected these arguments in accordance with the war crimes law that prevailed at the time. As legal scholars have pointed out, the fact that Japanese soldiers and leaders were prosecuted, whereas their Allied counterparts were not, doesn't negate the crimes with which the Japanese were charged. In other words, justice was still served if those alleged Japanese crimes were examined in court. But nevertheless, justice could be said to be incomplete in that case. The one-sidedness of the prosecutions gave rise to the powerful accusation that the trials constituted what later came to be called victor's justice. It's supposed to be an impartial application of principles of legal reckoning. It didn't look that way. The victor's justice argument has achieved a great deal of currency in the decades since the trials ended. International law no longer restricts war crimes prosecutions by nationality, but the issue of one-sidedness, or the perception of one-sidedness, does persist. A second acute problem in determining the culpability of Japanese defendants arose from the circumstances of the war itself, and especially from the economic dimension. A fundamental reason that Japanese military personnel committed atrocities in the first place was that their forces were drastically overextended. Japan couldn't prosecute this war effectively. Its industrial and military capacity were too small. Industrialized Japan had been the main hub of Eastern Asia before the war, but still Japan's economy was relatively small in comparison with those of the major Western powers. In 1940, the size of Japan's economy was just over 1/5 that of the United States, which was about to become its major enemy. As for the military, it was less than half the size of the US military. The war itself made things much worse. When Japanese leaders conquered and occupied Western colonial territories in Southeast Asia from 1942 on, they claimed that their actions were designed to liberate Asia from Western colonialism. But even if they did do that, the liberation entailed separating the former European colonies in Asia from the Western markets on which their economies had come to depend. Japan's economy couldn't absorb the plantation and mining products that had been the mainstay of colonial economies. Nor could its factories at home or in the occupied territories deliver enough of the consumer and the technical goods that were needed by people of former colonial regions. Japan's own agricultural production as well had less and less capacity to meet either military needs or civilian needs. In comparison with the wealthy United States in particular, where production soared during wartime. Japan had few natural resources of its own, and it had just declared war on the territories that had previously produced most of the petroleum and other essential war materials that Japan had been importing. In other words, the US, Britain and its overseas territories, and the Netherlands and its empire. Another factor was the critical shortage of the shipping that was needed to bring in military supplies as well as fresh troops. In 1943, a third of Japanese army supplies sent overseas was lost because of ship sinkage, including half of the supplies sent to the Philippines, which was a crucial battleground at the time. In the first half of 1945, ship sinkings were responsible for the loss of 50% of Japanese military supplies sent overseas. The situation was greatly worsened by the Allied blockade of Japanese occupied islands that began around the middle of 1943, because even if the ships weren't sunk, it meant they couldn't get through. The net result was that Japanese troops were never properly supplied with food or medicine or clothing or ammunition or construction equipment or transport or personnel, either for their own use or for the livelihood of prisoners under their control. In the historian Edward Drey's words, logistical support for Japanese forces was always teetered on the edge of collapse, and operations were usually conducted on a logistical shoestring. To compound these problems, Japan's military forces were also geographically overextended. All the while it fought in the Pacific, Japan was simultaneously fighting a very demanding war in China, which had begun in 1937. This conflict in China always absorbed the greater part of Japan's limited military resources. The army was already overstretched in China before the war with the United States and its allies even began in December 1941. And finally, the territories Japan conquered and occupied were widely spread, encompassing remote and inhospitable areas with very little usable infrastructure, including roads, railways, and local labour forces, and subject to endemic diseases. This lack of infrastructure and the difficult environment meant that food and medicine, already scarce, often couldn't get to where they were needed. So Japanese forces were very thinly stretched. The situation was especially acute in the final year of the war, when critical shortages made life exceedingly difficult for everybody in Japanese-controlled regions. Then the economic exchange between Japan and its occupied territories and amongst those territories was further hampered by the growing intensity towards the end of the war of Allied aircraft and submarine attacks on Japanese shipping. It all got very, very horrible. Hundreds of Japanese vessels were sunk, which made it increasingly difficult to export raw materials from Southeast Asia or to import manufactured goods. So, what does all this have to do with the war crimes trials? One of the most common charges against Japanese staff working in camps, and remember I said that camp charges were quite prominent among the war crimes trials. One of the most common charges against those who had custody of prisoners of war or civilian internees was that they had deliberately or carelessly deprived detainees of food and medicine. Japan was bound by the 1907 Hague Convention on the Laws and Customs of War. Laws and Customs of War on land, that is. Broadly speaking, its provisions required Japan to provide prisoners with the same conditions that it provided for its own troops. That was the rule. But the convention hadn't anticipated the acute shortages that afflicted the Japanese Empire in its final year of existence, especially. Judgments in early Allied tribunals were inclined to hold Japanese defendants very strictly responsible for a failure to adhere to peacetime standards of supply and sometimes meted out harsh penalties. Later tribunals, in fact, were more inclined to recognise the impossible circumstances that camp management had found itself in and to pass somewhat lighter sentences as a result. But overall, the war crimes trials appeared to be blaming camp staff in particular for circumstances over which they had little or no control. This situation further undermined the perceived legitimacy of the war crimes trials. It provided even more fuel for a perception that the trials were not fair, that the military personnel who were convicted were simply ordinary men caught in impossible circumstances, yet were made to suffer harsh penalties. A further implication was that if anyone was to blame, it was the political and military leaders who had sent their men into impossible circumstances in the first place and then had abandoned them to bear the consequences. And that view also undermined the perceived legitimacy of the trials, as it implied that the wrong people were in the dock. The third major problem faced by the tribunals lay in how they could attribute responsibility for specific criminal acts to individual Japanese service personnel. If we think about civilian life, most crimes involve a single individual or a very small group of planners and perpetrators. Where larger groups are concerned, legal systems sometimes invoke the fairly problematic concepts of conspiracy or joint criminal enterprise as a way of bringing individuals who were not directly involved in committing a crime into the scope of prosecution. Atrocities carried out by serving military personnel in wartime presented the problem of responsibility on a really vast scale. The Imperial Japanese Army and the Imperial Japanese Navy were legal organisations. They had the respectable task of defending the national interest, as did the military services of their adversaries. They were hierarchies in which general orders were issued from above, gradually becoming more specific as they proceeded down the line. In their wartime deliberations, that is before the end of the war, Allied officials who were planning ahead for war crimes trials had been determined to avoid a situation in which only the most junior soldiers who actually carried out, say, illegal executions or some other crime could be held to account. They were committed to reckoning also with those who'd given the orders and had failed to take steps to prevent their subordinates from committing atrocities as well. So it wasn't just giving orders, it was a failure to prevent atrocities or to halt, failure to prevent or halt. Neither conspiracy nor joint criminal enterprise was a plausible legal means of distinguishing between two things. On the one hand, the proper adherence to superior orders. Every military demands that. So obeying orders is a normal and required thing. On the other hand, responsibility for specific atrocities. How do you separate them? To deal with this issue, the tribunals developed the doctrine known as command responsibility. Under this doctrine, officers could be held responsible for the actions of their troops, not only if those troops were obeying direct orders, but even if those orders had never been issued, providing that the troops were acting in the belief that they were following official intentions. A very large number of the Allied trials of Japanese suspects were based on the doctrine of command responsibility. The principle seemed straightforward and fair. It was the result of an honest attempt to grapple with the problem of responsibility for criminal actions in wartime, and an honest attempt not to put all the blame on the lower ranks. But in practice, command responsibility proved to be an uncertain and an ambiguous legal doctrine, and a really difficult one to handle. In the first and most celebrated trial invoking command responsibility, it was an American tribunal. It brought down a guilty verdict on this fellow, Japanese General Yamashita Tomoyuki, for crimes committed by Japanese troops in Manila in February 1945, as the Americans were taking back the Philippines. Even though those troops had acted without his orders, and he was located more than 200 kilometres from the scene of the crimes, in circumstances where communication was very difficult. So it's not even evident that he knew what was happening. Yamashita was executed for these crimes in an outcome that has generated great controversy ever since. Some authorities, even at the time, worried about the implications of this judgment. As one American judge in another case mused later, if America had lost the war, perhaps General Douglas MacArthur, their supreme commander, could have been held responsible for the crimes committed by any American soldier. Perhaps even the president, as commander-in-chief, could be held responsible. It was soon realised it was a really risky doctrine. But it continued to be used. Not only very senior generals like Yamashita, but many lower-level commanders were also found guilty of the crimes of their subordinates. But in some cases, prosecuting teams recognised the remoteness or the incompetence or the ignorance of commanders and declined to pursue them for crimes they had not directly perpetrated or did not punish them severely. So, at best, the application of command responsibility was inconsistent and unpredictable. The Allied authorities overall conscientiously tried to deal properly with Japanese war crimes and to reduce the difficulties that arose along the way. But the three problems I've outlined, lack of universal coverage of war crimes by both sides, disregard for the difficult context of the war, especially the economic context, and the uncertain application of command responsibility, these all worked powerfully against the reputation of the trials. In the end, these problems reinforced a sense in the post-war period, especially in Japan, that justice had been applied unfairly and only against the losing side in the Pacific War. Okay, so what happened next? I want to make a few exploratory remarks about this. In doing so, I am going beyond my specialist knowledge of the context. My interest is in the continuities between what happened in Japanese war crimes trials after the war and in later events. Allied leaders intended that the standards they believed they'd set in the trials following the Second World War would be upheld far into the future. In fact, ideally forever. And again, ideally, the post-war reckoning would prevent further war at all. That was the lofty aim. At the opening of the Tokyo trial, the chief prosecutor, Joseph B. Keenan from the United States, declared resoundingly that prosecutors, and perhaps by extension the court and the Allied powers, were, quote, waging a part of the determined battle of civilization to preserve the entire world from destruction. So you see they had a pretty ambitious set of aims. At the least, if more conflicts did occur, military personnel would be held to high standards of behaviour. And yet, Despite very many conflicts after 1945, war crimes prosecutions didn't resume until the establishment of the International Criminal Tribunal for the former Yugoslavia in 1993 and the International Tribunal for Rwanda in 1994. There was no formal reckoning for atrocities committed in the many wars that had broken out in the interim decades. So, no formal reckoning for atrocities committed in the Vietnam Wars of 1946 to 75, the Indo-Pakistani Wars of 1947, 1965 and 1971, the Arab-Israeli War of 1948 and 49, the Iraqi-Kurdish Wars of 1961 to 70 and 1974 to 75, the Cambodian-Vietnamese War of 1978 to 89, among numerous others, not to mention colonial wars like the British suppression of the Mau Mau Rebellion in Kenya in the 1950s. Charges against national leaders in international courts for the waging of aggressive war, that is, the charge that was laid at Nuremberg and Tokyo against the leaders, have not been used again since 1948. The first major test for the new apparatus of international law had come just 5 years after the end of the Second World War, in the form of the Korean War of 1950 to 53. This was a brutal conflict. Atrocities were committed on all sides and were quickly reported to military authorities and in the world's presses. United States authorities were determined to pursue atrocities committed by their enemies, the North Korean and the Chinese forces, and to do so through legal channels. From the early stages of the conflict, official pronouncements indicated that the United States intended to prosecute war crimes and expected that the standards they'd set so recently in the trials following the Second World War in Europe and in Asia would be upheld. Planning began for war crimes trials, evidence was collected, legal briefs were prepared, all very much on the model of what had been done in the Pacific War. But in the end, these plans foundered and no war crimes trials were held. Part of the explanation was familiar from the earlier war. It was difficult to find reliable evidence and to identify and apprehend suspects for much the same reasons. But the War Crimes Trials project also failed in Korea because in a few short years, it had become obvious that the model that had been used against German and Japanese suspects was not nearly as robust as many people had thought and would not work in different circumstances. Two things were especially important. First, there was no clear-cut victory in the Korean War. The conflict didn't end in overwhelming military victory as it had in the Second World War in both Europe and Asia, but rather was concluded through the efforts of diplomats. An ambiguous ending like that was a bit difficult to reconcile with war crimes trials. And second, it was a matter of public record that all sides had committed atrocities, including and especially the South Koreans, who were allies of the United States, not enemies. In the trials after the war in the Pacific, Japanese defendants had been prevented from raising offences committed by the Allies. In the Korean War, the international community had plenty of evidence of South Korean atrocities because of all the press reports, and it also had evidence of brutal actions by American forces. It was no longer possible to sweep these things under the carpet and to raise a division between the righteous and the unrighteous sides of the war. Victor's justice would no longer be enough, and so apparently it was better to have no justice at all for the Korean War, at least not formally and not at that time. As you know, war crimes and possible war crimes trials are very much back on the international agenda. In Australia, an official report in 2020 found credible evidence that Australian soldiers had murdered civilians and prisoners in Afghanistan. Similar allegations have been made about British and American soldiers. The obstacles to investigation of these alleged crimes are strikingly similar to the obstacles that faced investigators of Japanese war crimes decades ago. Witnesses might be dead or otherwise unavailable or unwilling to talk. Documents might have been destroyed or lost. Crime scenes will have been disturbed. In the Australian case, investigators have estimated that it could take up to 5 years before evidence can even be presented to the Director of Public Prosecutions, let alone before legal proceedings could begin, which, if it did happen, would be bound to be lengthy. In Ukraine also, the crimes that are alleged to have been committed by Russian forces are very much the same types as those for which Japanese and Germans were tried. Evidence has been collected of mistreatment of prisoners, theft, needless destruction of cities, and destruction of things that civilians need, like food and water. Just as in the Second World War, there is a very strong desire for justice for what seem like obvious crimes against Ukrainians. Investigators have got lots of material, including video footage now. Ukraine has a number of Russian POWs in custody, and some will be war crime suspects. But what are the prospects for trials? Again, there are both practical and legal obstacles. The International Criminal Court in The Hague is one of two senior international courts, so to speak. The International Criminal Court targets individuals suspected of war crimes. It's an obvious place where trials could be held, but there the problems begin. Not all countries have agreed to cooperate with the ICC or are full members, so complicated questions of jurisdiction immediately arise. Russia, along with the US, China, Israel, and others, have announced that they don't intend to become parties to the court. Indeed, you may have noticed that a week ago, US President Donald J. Trump authorised economic and travel sanction against the court's staff because of the actions that the ICC has taken against the United States and its ally Israel. Meanwhile, the court had already opened investigations into the unlawful deportation of children from Ukraine to Russia and into Russian attacks on Ukrainian civilians. Warrants of arrest have been issued, including one for President Putin. The most obvious problem is that it's highly unlikely that Putin or other suspects can ever be arrested and brought to trial. There's another court, the International Court of Justice, as opposed to the International Criminal Court. The International Court of Justice hears disputes between state parties rather than dealing with individuals. In 2022, the court ordered Russia to suspend its military operations in Ukraine. But the ICJ has no capacity to enforce its orders if any of the 5 permanent members of its council exercises their veto power, and Russia is one of the 5 permanent members, so nothing happened after the court ordered Russia to cease its military action. Another avenue is for Ukraine to hold its own trials, which is already happening. Practical difficulties in investigating and prosecuting war crimes in Ukraine are not hard to identify, but according to Ukrainian prosecutors, captured Russian soldiers have been tried and convicted of rape, murder, shelling of civilian infrastructure, and other crimes. As with the proceedings after the Second World War, a major problem is whether the main offenders will ever be apprehended. The trials that have been completed or that may be underway are trials of direct perpetrators. The prospect of holding Russian commanders or leaders responsible for war crimes is very slim. In the first of the war crimes trials held in Ukraine, this 21-year-old tank commander pleaded guilty to murdering a Ukrainian civilian and was given a life sentence. The court recognised that he had been ordered by his superiors to shoot the unarmed civilian, but sentenced him to life imprisonment on the grounds that he shouldn't have followed the order. After an appeal, the convicted man's sentence was reduced to 15 years. Higher-level war crime suspects usually can simply stay out of the way, such as by remaining in Russia. The Russian government won't cooperate with investigations or extradition. The same course of action, staying out of the way, has been followed in other parts of the world, including the former Yugoslavia and some African countries. Another challenge, if Ukraine continues with its own prosecutions, will be to forestall the perception of one-sided trials. It's difficult now for a victim state or for any state that's party to a war to present itself as impartial and to present the other side as the sole perpetrators. Ukrainian soldiers too have been accused of executing Russian prisoners of war, for example. So I want to conclude by asking what lessons we should draw from the legal proceedings that took place after the Second World War in Asia and the ones that failed to take place after Korea and after other conflicts. I think there are at least 4. The first is that prosecuting suspected war criminals is an extremely difficult undertaking, no matter how straightforward the issues might seem to be. Problems range from practical obstacles like gathering evidence to higher level jurisdictional matters. A second lesson is that war crimes trials of the type used after 1945 against Japanese and German suspects require specific conditions, including a clear victory, which gives a mandate for one side. If there's no such clear-cut result, war crimes trials become problematic, or at least a different model has to be used. An important third lesson is that one-sided prosecutions are absolutely a recipe for trouble. Victor's justice, that is the exercise of justice by the victors only, has no credibility, especially in the longer term. And problems tend to grow with time. A fourth lesson is that questions of military hierarchy will always dog war crimes trials. There is no simple answer to the question of who is ultimately accountable for a war crime and how far up or down the chain investigators and prosecutors should go. Thank you very much for your attention.
Thank you. Thank you very much, Professor Wilson, for this very thought-provoking lecture. I am a student of history and currently studying law, so it's been interesting to understand international law from this perspective. And I have a lot of questions, but so I'll go first because we are running a little short of time. We have about 10 minutes, ladies and gentlemen, 15 minutes for Q&A. So please keep putting your questions in the chat box, but I'll get started. I use the chair's privilege to ask my questions. Ma'am, I was quite surprised by the fact that when you said that the allied that the defense was sort of restricted to the Axis powers. So I was thinking that was there no acknowledgement of the events that happened on the 6th and 8th of August, Hiroshima and Nagasaki, 9th of August, Hiroshima and Nagasaki. There was no acknowledgement of that, let alone a trial. Of course, we've mentioned that there was no trial for that. But did US and the Allied powers never even talk about it, or what happened on those days was incorrect? And how did Japan react to this blatant ignorance of the Allied powers to the events that conspired on those days and when they were being subjected to trials for doing inhumane treatments of similar level? So that is my first question, and I have a few more.
I'm sure you're not the only one who would have asked that question. The atomic bombings were considered differently by the Allies at that time from the way they would be now. There was an overwhelming doctrine, still is, I imagine, called military necessity. So if an action is taken out of military necessity, it is justified. So it relates to that point that I made about whether actions are related to military goals or not. So the atomic bombings were always presented as a necessary way to end the war, and they were justified on that basis. The principle of proportionality that I mentioned is one that's expanded much more since the end of the Second World War. So bombings of whole cities now, such as we've seen in Ukraine, for example, would be incontrovertibly a war crime because they're so disproportionate. Because there's one platoon in the city does not mean that you can bomb the whole city to bits. But that was a less developed principle at the time of the Second World War, and the Allies, as I said, justified their actions out of military necessity. Japanese reactions, it took some time for reactions to fully mature, partly because Japan was occupied from 1945 to 1952, and the Americans brought in their own censorship. They took away the Japanese censorship, brought in their own censorship. It wasn't until 1952 that the full story of the atomic bombings was known by all Japanese. Of course, those who were in the area knew, but the opposition to the atomic bombings is really mostly a mid-1950s onwards phenomenon, and is now very acute. Yeah.
Thank you, ma'am. Ma'am, my next question is that of course, the World War marks this sort of an advent for international law or the coming of an international community, so to speak. And so when Japan, and like you said, that the reaction started coming from the 50s onwards, was there any mention of the Japanese feeling alienated in the international community, or of them openly saying that international law has neglected us, or it's extremely one-sided or unfair? Or is this, again, this realization a later product that international law is like you mentioned in the concluding slide as well, that it's one-sided. So was Japan one of the first people to realize this because they were victims of one-sided fair trials, or not, or they did not talk about this at all?
The victor's justice argument is very strong in Japan now, but that again was something that developed over time. I think most Japanese in the initial post war period were overwhelmed with the problems of survival, the enormous destruction that had happened. They were glad mostly that the war was over because the war was terrible for Japanese civilians too. And they were trying to get themselves back on their feet. At an official level, mostly the Japanese government and other authorities were keen to be reaccepted into the international community, which by and large they were in the 1950s and the 1960s. But certainly dissatisfaction with the war crimes trials did grow. The term victor's justice, as far as I know, was first applied by the American historian Richard Manier. I think his book is 1971, and he wrote it in the context of the Vietnam War, his protest against America's Vietnam War. So that brought up a whole lot of issues all over again too. Sorry, I can't hear you anymore.
Oh, sorry. Thank you very much, ma'am. Uh, my next question is actually related to the Vietnam War. When you said that there was no justice that was dispensed in the Korean War of 1950, was no justice dispensed in 1973, or because there was such a huge hue and cry by the Americans in the 70s that justice inevitably had to be dispensed in the favor of the Vietnamese and against US in this case?
I meant simply that there were no formal war crimes trials.
For any of
There, there were courts martial within, so the most famous one would be the court martial of Lieutenant Calley for the My Lai massacre. So there could be courts martial within, in that case, America's own military, but there were not international war crimes trials held. Again, the first, as I said, were 1993.
Ma'am, my next question is again with regard to I would say, sort of hesitance of the countries in joining the international community. Dear audience, a caution here. I realize that all of us, especially on this side of the world, are sort of novices to this argument and law. So please feel free to ask questions. I know I'm asking really childish questions right now, but please feel free to ask those questions. So, ma'am, my question is related to that when there has been, and we keep coming back to this point, when there has been such a gross misjustice or injustice at the part of the allies, why didn't any of the third world countries or developing countries hesitate to join the United Nations, or was there some hesitancy in joining the United Nations and the ICJ subsequently, or is there no hesitancy in joining that when there's?
I don't know enough about third world countries joining the United Nations. Japan was very keen to be readmitted to the United Nations, faced some opposition throughout the 1950s, and finally got in 1956. I'm not sure about other countries about that. Sorry.
No worries, ma'am. Thank you for your answer. But if we could come back to the fact that this was considered a necessary way, that the allies just justified this as a necessary way of combating justice. Was there no voice coming from the United States or from the allied powers that this necessary way is too extreme? We realize that
Do you
Japan is
mean do you mean the atomic bombings or the war crimes trials?
both, that this
Both.
necessary way is just too extreme to even be justified. Are none of the allies also saying, muttering about this within themselves? Do we have any instances of that happening?
As for the war crimes trials, I don't think so. There were some leaders, Roosevelt and Churchill among them, who initially wanted to just not have trials, just take people out and shoot them. But they were persuaded, they were convinced they knew who should be shot. They were persuaded against that. As for the atomic bombings, yes, there were voices within the United States against it after it happened, because not very many people knew about the bombs before they were dropped. Dwight Eisenhower was one who thought they should not be dropped. He thought the war was already won, don't do it. After they were dropped, there was a minority, but certainly American critics of the bombing were there right from the start, from 1945. They were a minority, I have to say.
Thank you, ma'am. Ma'am, we have a question from Raghav in the YouTube live chat. He says, in the case of Japan, was there perhaps also a sense of national shame? And if yes, was it in any way exploited by the American occupying forces as a psychological subjugation?
As far as national shame goes, the war crimes trials played an interesting role because for many Japanese, it was the evidence brought forward in the trials that was their first information about some of the terrible things that had happened. So yes, there was national shame among some people about the stuff they were hearing about massacres and executions and awful treatment of prisoners of war. I don't think the Americans felt the necessity to exploit that because their power was already overwhelming in the occupation. They had many levers of control. And they were busy remaking all of Japanese society, really.
Ma'am, we have about 6-7 minutes. So if we could ask one of our last questions, and that is about the Nuremberg trials. That is one of the most famous trials when we talk about the World War. And the fact that the Nuremberg trials is, like you said, it's a clear-cut example of victor's justice. Do we have the Japanese side or the defendants saying anything about the misjustice? Or again, were the Japanese and the vanquished forces too busy defending themselves that they did not have the opportunity to realize that justice is only being dispensed against them and that they don't have any chance of retribution in when the Nuremberg trials began?
The Nuremberg trials, you mean the German trials?
Yes.
Or do you mean the Tokyo one?
We could talk about both. Like we said, it's little known about here. So if you could give us a brief introduction to that, because that's the only trial that one hears about where the Nazis.
Nuremberg trial.
Yes.
The Nuremberg trial had a very similar framework and very similar issues. Again, Germans would not have been allowed to raise any Allied atrocities, just as they weren't in Tokyo. In the Japanese trials, some defendants and some lawyers did try to raise, especially the bombing of cities. They tried to talk about it. They made really interesting arguments about the Allied willingness to use those weapons and unwillingness to allow any justice to be had for them. I'm not sure whether the same thing happened in the German trials. I imagine it probably did. But of course, well, the Japanese had the atomic bombings. There were extensive bombings of German cities. So I imagine the same issues must have arisen.
Thank you very much, ma'am. This is the last call for any questions that the audience might have. We have about 2 to 3 questions. Raghav, thanks you for the answer, ma'am, for your answer to his question. With that, ladies and gentlemen, we come to the end of the lecture. Ma'am, if you could please be a little selfish here and ask you about your experience of interacting with the Indian audience and with your experience of working of giving a lecture here at Karma.
I wish I was in the room and then I could see people and it would be much better. But it has been a very interesting experience to do this and to hear what kind of questions you have from your own perspective, which is different from what I usually hear. So thank you very much for this opportunity, and thank you to the audience for listening and asking questions.
Thank you very much, ma'am. If I could use this opportunity to ask one last question with regards to the information, ma'am, we do realize, and India has had the partition and everything. The concept of reparations is only now being started being asking. How informed are people of the concept of war trials? So I'm not just talking about it historically. I'm even talking about it in the contemporary times now that we have seen 2 major wars that are happening in the world as we speak. Is the concept of war trials understood by people enough? And how important are war trials for common people? Or is it something just to do with law and it's to do with the topmost rung of politicians and statesmen? Is war trial necessary for common people as well when justice and politics is being?
I think ordinary people do think about it. If we think about Ukraine, people were horrified about what happened in Ukraine, and there is a natural desire that something should be done to stop it and to bring justice. And I think that happens in other conflicts as well. One of the things we notice in Australia, and I'm sure it's the same elsewhere, is that it really depends which side you're on. The calls for prosecution of Australian soldiers for possible war crimes in Afghanistan have got a great deal of social resistance because the arguments come out. It's wartime. They were only doing what they had to do in war. Nobody raised that argument when the Japanese were in the dock because nobody in Australia did. So they were getting what they deserved. But when it is a matter of our own soldiers, that is different. They were only doing what they had to do. So yeah, I think it is a topic that arouses passions with ordinary people too, and it isn't going away. There are war crimes issues around us right now, as we know, which are really difficult to think through.
Thank you. Thank you very much, ma'am, for your insights and for answering all our questions in such great detail. Dear audience, that brings us to the end of this Karma special YouTube lecture. Thank you again. Thank you very much, Professor Wilson, for your time, for your scholarship, and of course for giving us your time here to answer our questions and to give a lecture to our audience here at Karma Heritage. We eagerly look forward to hosting you again in the future and trouble you again with some novice or beginners questions. But thank you for
your questions are fine. Thank you very much for asking.
Thank you.
And thank you again to the audience and to the organisers. It was a good experience. Thank you.